Nerede online? No.
Hi everyone, good afternoon again. You have Freshfields and ECAS here. So we've heard quite a few people joining and we're keen to start off so as not to eat into your afternoons more than necessary. As a point of admin, could I ask you all to mute your lines while we are giving the presentation? But then, of course, afterwards, if you have questions, there will be an opportunity for you to So I would then hand over to Elisa, who's going to kick us off with an introduction.
Okay, good morning everyone. I'm Elisa, the Digital Democracy Manager at ECAS, and I'm here with Flavio, who's also the Digital Democracy Assistant. So basically, I just wanted to give you a brief introduction of what we're working on at the moment with SecGen, the Commission, and plus the European Service Network and CARTA. So as we have told you recently, we're working on this online collaborative platform for the European Citizens Initiative. And this was an initiative, well, it's actually funded by the Parliament. One of the parts of the budget of the Parliament has been given to the Commission in order to basically create a sort of platform which will support organizers of the European Citizens Initiative.
Sorry, can we again ask, could you please keep your line muted just that everyone on the conference can hear properly what's going on? Thank you.
So this is a pilot project. So it started, the development actually and implementation of the platform started only this January, and the pilot project will be running until November this year, but we have already received the news that most probably there will be an extension for another year. So here we're happy to have you all as the experts, because what ECAS will be doing in particular is to handle citizens' inquiries regarding the legal advice that we would like to give them when they are drafting their ECI proposals. Now, in the past few years, we've been running the ECI support center, and we've been collaborating already with Freshfields on a more informal basis. And here we have Angeline and Daniel, who are working closely with me on giving legal advice to potential ECI organizers. And we're very happy that now with this online collaborative platform, what we were doing informally through the ECI support center is now going to be a formalized, inquiries, legal advice to citizens. And we're really happy that you have decided to join us. It's a pilot project, as I said. We do not know how many inquiries we will be receiving in the first year. It's absolutely not in the huge scale that you've been receiving with your advice. So we take it as a really learning moment in order to see also if actually citizens appreciate this sort of support when trying to use this tool. As you know, there have been very few ECIs which have been successful. Only a bit more than 60 have been sent to the Commission in the past 5 years. So we're not talking about a huge amount of inquiries. And we have also sent you the terms of references. I hope that you have had the time to check them, and please send me a confirmation email once you agree to them. We've been saying that you can work in teams of 2. The reaction time, I've had this comment, seems to be very, very brief, but actually you can be working in teams of 2, so it's no problem. We're here also to try it out and to see. But before we go there, if you have questions. Also on the terms of references, I'm here to answer your questions after the presentation by Angeline and Daniel. And so I would now hand the floor to Angeline so that we can start at least the ECI training for you.
Thank you, Elisa. It's a pleasure to be involved with this very important initiative and to have the chance to meet all of the legal experts, at least by telephone. So indeed, we have been working with ECAS in recent years on a more informal basis, and we are now at the stage of formalising the kind of support through this important project. I think in terms of today's training, a couple of preliminary points. So you'll maybe be relieved to hear that today we are not going to discuss everything chapter and verse and go through every previous initiative in detail. Rather, the purpose is to make sure that all of us are on the same starting point in terms of the legal background, and also where to find the best resources. What we have found in the past is that the best training comes on the job, and as and when initiatives come in for review, I think it's going to be really important that we all of the experts and everyone at ECAS, that we take stock after a number of inquiries, that we find ways to share best practice and tips and know-how. So with that introduction, I would hand over to Daniel, who's going to provide on the legislative background to the ECI.
Thanks very much, Angeline. It's Daniel Baker here. So we thought we'd start today's session in terms of the substance, at least, by sketching briefly the background to the ECI regulation. People on the call may have greater or lesser familiarity, so I think it's worthwhile just giving a bit of historical perspective. So the Treaty of Lisbon, which was ratified in 2007, is the first, is where the ECI initiative sort of came into being. Now, prior to this, their direct democracy or instruments of direct or participatory democracy played no role in the EC treaties. The only examples we had really was a right to petition the European Parliament, which is pretty limited. This right still exists. So the ECI, the European Citizens Initiative, is a novel instrument of direct participatory democracy, which is within the EU legal order, and as such is I think is an important tool as it aims to address this idea of democratic deficit and is really meant to bolster the legitimacy of the EU institutions. So the Treaty of Lisbon inserted a couple of articles into the main treaty. So the Treaty on European Union, Article 11 specifically, and this is really just by way of background, that is the article which sets out that there will be this ECI, and basically it says in paragraph 4 that if at least 1 million citizens sign up to an initiative, then the European Commission will take a look at it and consider whether it will propose legislation. And then in Article 24 of the Treaty on the Functioning of the European Union, there is again a reference of the right to European citizens to be involved in an initiative. Now, flowing from this, the ECI itself is set up by secondary legislation, and it is the Regulation EU number 211-2011, or the ECI regulation. So that was brought on the books in 2011. And it came into force on the 1st of April 2012. So the 1st of April 2012, basically pretty much 6 years ago now, was the first date in which it was possible for organisers to apply to the European Commission to have their petition or their proposal registered. And as Eliza's already mentioned, since that time, there have been 65 citizens' initiatives which have been proposed, which have been put to the Commission for a registration. So that's around 10 per year on average. Of those, only 4 have been successful. And by successful, that is, not only have they been registered, but the organisers have gone out, they've gathered 1 million, or at least 1 million signatures, statements of support as they're called, and they have brought them back to the Commission, and then the Commission has taken certain steps. Now, along the way, there have been around 17 of these 65 which were refused registration. And interestingly, if you look at the dates of those, the majority of those actually were refused in the early days. And this is where, Eliza will be able to tell you, there was a lot of teething problems when the ECI first came out, and there were a lot of rejections. And I think it's fair to say now that both the Commission itself and us as organisers are smarter in bringing these forward, and that's where this group comes in. So a number have been withdrawn, and then 24 in total have been registered, but then they have failed to get the requisite number of signatures, and so have not been taken forward. But that's a bit of an overview. And if you look at those that have been successful, just the topics, of the 4 that were successful, one is relating to vivisection, another one was about water being a human right, another one had to do with the right to life, I believe, it was one of us, and then there's another one on glyphosate, so a non-selective herbicide, which obviously is a cause for concern. So you can see that the topics that are being covered are the sort of hot button issues that many people feel. And actually, I think that's a good segue into the next section, because there is, I think, a tension in the ECI regulation between what the Commission is able to do within the framework of its powers and under the treaties, and some of the issues which cause concern across the EU. And often, I think there's a mismatch between what organisers hope they can do with an ECI and what's actually possible. And part of the role of the experts and the support team is, in a sense, to bridge that gap and help, focus the attention of the organisers and get them, and enable them to move forward in some way. So if we just go to the next slide, we've highlighted here, just really as an overview, the key stages in the timeline of an ECI procedure. And from start to finish, we're talking about a process that can last up to 2 years or thereabouts. Not only does it take a while to prepare, to set up an organising committee, then you have to get it registered, so you have to put a proposal on its feet, you have to send something into the Commission. The Commission then has a couple of months, has 2 months to consider it and decide whether to register. And then if it does register the proposal, then it has another month where it certifies the online system which is used to gather the statements of support. And then the clock really starts ticking. There's the 1 year period when the organisers have a year to go and get these 1 million statements of support. And once those statements of support have come in, there is a 3-month period where the national authorities in each of the member states where those signatures have been collected will verify that they have been, that they are properly collected. So that means, checking that the correct information has been required, that the signatures have been collected within the dates. If a signature is collected after the date, then they will be excluded. So that verification process takes 3 months. And then the organisers can have a think and decide whether they want to submit that then to the Commission. And there's no particular time limit for that, but obviously if you've got that far, people are going to be keen to put their proposal before the Commission. And then once the Commission receives that, the Commission itself has 3 months to consider those proposals. In that time, there is an opportunity for the organisers to have a public hearing, and the Commission then will give a written response to those concerns and will set out what the Commission and what the institutions are already doing, if there is something that's being done, and then will state what they intend to do going forward. So that process, as you can see, can take the best part of 2 years and is a significant investment for the organisers who do this. So I think zooming back in or focusing now, where we are looking today is the second stage of this process, which is the legal test. And the registration by the Commission of a proposal is the first hurdle, if you like, in the life of an ECI. And as we can see from the number of rejected ECIs, so 17 out of 65, so nearly a third, not quite a third, have been rejected. So that's a significant amount of time and effort that people have put in to proposals which don't see the light of day. And so that's where we come in and where we hope that we can help these organisers be more successful. So if we look a little bit more at the legal test for registration, what I want to do now is just zoom in a little bit on the ECI regulation itself, which is where the requirements, the detailed requirements for carrying out an ECI and or bringing an ECI forward are stated. And it's worth, I think, saying here, for those of you who haven't looked at the ECI regulation, it's well worth doing that. And I would say, if this is your first time looking in this area, I would recommend firstly look at the articles I've mentioned, Article 11 of the Treaty on the European Union, Article 24 of the TFEU, and then print out a copy of the ECI regulation and familiarise yourself with the framework, with the architecture of that, because this is the basis on which everything rests and from which everything flows. And for our purposes, the legal test is in Article 4 of the ECI regulation. And the ECI test sets out what has to be fulfilled if the Commission is going to register. And it says the Commission shall register a proposed commission provided that the following 4 conditions are fulfilled. And so the first one is, a citizens committee has been formed. That's pretty obvious. C and D of this article are that the ECI is not manifestly abusive, frivolous, or vexatious. And then also D is it's not manifestly contrary to the values of the Union in Article 2 of the TEU. And then point B, that is really where all the action is in terms of how the Commission looks at these proposals in practice. And so far, as far as I'm aware, all of the ECIs which have been rejected on the basis of Article 4.2b. And that states that the proposed citizens' initiative does not manifestly fall outside the framework of the Commission's powers to submit a proposal for a legal act of the Union for the purposes of implementing the treaty. Now that is quite a mouthful, and if this is the first time you're seeing this, you'll be forgiven for wanting to reread that in the privacy of your own home or office at some point just to get hold of it. But let's talk about it for a little bit. I mean, I think the key wording here is that it must not manifestly fall outside the framework of the Commission's powers. So this idea is, I think the key bit there is, what is the framework of the Commission's powers? What are we talking about there? And the second element of that is the requirement to submit a proposal for a legal act of the Union. What is meant there? And then, for the purposes of implementing the treaties. Now, first off, what we can say is, if the ECI seeks to ask the Commission to do something which is outside the Act, outside the scope of the treaties, it's a non-starter. So I'll give you an example. In the early days, of ECI, there was a proposal that said that citizens of a new state which has seceded from a member state should be citizens of the EU. Now, this may be a very laudable and worthwhile proposal. It just happens not to have any legal basis in the treaty. This subject matter is not the subject matter of the treaty, and it's a complex area of international law. And if this proposal were to be brought forward, it would require an amendment to the treaties. So that's the first thing to note, is that blue sky thinking as to how we're going to change the constitutional order of the EU is just not going to work. So it has to be within the framework of the treaties, and I think that's an important point to remember when we're discussing this. And linked to that is a point that we'll talk about a bit more in a minute, is that when we are advising ECI supporters about the legal basis for their proposal, that has to be a legal basis in the treaties, and this is primarily the Treaty on the Functioning of the European Union, the TFEU, but also secondarily on the Treaty of the European Union. It does not include and will not include international treaties, the Universal Declaration of Human Rights, Magna Carta, you name it. It doesn't include however many great legal instruments have been drafted over the years. If it's not within the framework of the treaties, it's not going to fly. And sometimes legal organizers get really carried away with all of this great stuff that's been passed by the UN and other bodies, and it's nice as it may be, it's irrelevant. Okay, so it doesn't manifestly fall outside the framework of the Commission's powers. So the Commission's powers is subject to the treaties, but within the treaties, the Commission has enumerated powers. It can't do everything, and it's important to understand where those powers are and what they are. Now, we're not going to go through all of them now, but as Angeline has mentioned, there is a fantastic website that the Commission hosts relating to the ECI, and this actually is going to be your best friend in terms of a resource to explain pretty much every aspect of the ECI, and there, amongst other things, they have a list of the Commission's competences. And just for your reference, I mean, the competences of the EU are set out in Articles 3 to Article 6 of the Treaty on the European Union, and they set out, I'll give you an example. So the Union shall have exclusive competences in the following areas: customs union, competition rules, monetary policy, common commercial policy, shared competence in areas of internal market, social policy, agriculture, etc. So in terms of a legal basis, that's where these areas are, and any ECI has to fall within those areas. Now, not every area of competence, of EU competence, is an area where the Commission has power to act. There are a number of institutions, a number of the lawmaking structure in the EU. I mean, the Commission is the primary proposer of legislation, but also the Council and the European Parliament, in certain circumstances, have a specific role. And in terms of where the ECI is, what the ECI can do, it's only if the treaties give the Commission power to propose a legal act is that a valid legal basis to propose an initiative. So if there is an article which says the Council shall propose with the advice of the European Parliament, or whatever it may be, it doesn't work. And that's something to bear in mind, that it's only the Commission. The ECI proposed citizens' initiatives are directed towards the Commission, and the Commission only. Now, and we'll talk about that a bit more in a minute, but another element of this is the proposal for a legal act. What do we mean by a legal act? Well, that means, the Commission is, the EU is a legal structure, and the bodies of the EU can only act in certain ways, and there are certain limited legal acts of the European Commission, or of the European Union, which the Commission can take. In framing these proposals, it's important to make sure that what organisers are asking the Commission to do is something the Commission can do in terms of the legal acts it can take. Okay, so let's go on to the next slide. Yes, I think just to remind everyone, I think there's a couple of people or somebody at least that's not muted. Could everyone make sure their phones are muted because there's some background noise? Thank you. So this is the next slide we have here is an example. Sorry, we still have somebody who's not on mute. Thanks. We have an example here. This is just to illustrate the point I made about this legal hurdle. And whenever the Commission rejects or refuses to register an ECI, it is required to issue a decision explaining why it has done that, explaining the reasons for its decisions. Now, when the Commission registers a proposal, it does not have to give a decision. So there's a bit of a symmetry there in understanding the Commission's reasoning, and sometimes you have to say, when you look at ECIs which have been registered and you compare them to those which have not been registered, it's not always obvious why there is a difference. But at least it's instructive to look at some of the reasons why ECIs are refused. And I have here an example of one of the early ECIs, which is requesting the supreme legislative and executive power in the EU must be the EU referendum as an expression of direct democracy. Now, once again, that is a very fine statement, but it is outside the powers of the European Commission to propose a legal act. There is no basis in the treaties for this. And so if we look at, on the slides, what the Commission said in response to these organisers, they say, I regret to inform you that the Commission refuses registration of the proposed initiative on the grounds that it falls manifestly outside the framework of the Commission's powers to submit a proposal for a legal act of the Union for the purpose of implementing the treaties. That's that wording we have from Article 4.2b. And the Commission goes on to say and says, you do not propose any article in the treaties as a possible basis for your initiative. So this is a really good example of a bad proposal, because they're trying to do something which is outside the scope of the treaties, and they don't propose a treaty article that gives the Commission a hook to act. So that's just by way of example, and if you have a free afternoon on a rainy day, you can go and look at some other sample rejections, and you can see a similar pattern showing up. Now, just to home in a bit more about if we focus now on what do we need to get an ECI registered as opposed to not getting it registered. I've touched on these already, but we'll just go over them again. So there are three key elements that need to be met, or three conditions, if you will, that have to be met in order for an ECI, a proposed citizens initiative, to be registered. And the first one, we've talked about this already, is to find a policy area where the EU has competence. And if you go onto the ECI website, there is very helpfully on one of the pages there, and you're going to have to click through and familiarize yourself to find these exactly, but there's an FAQ section, and the FAQs set out the EU's competences and the European Commission's powers. And the EU's competences, I mentioned already that these are set out in Articles 3 to 6 of the, sorry, I misspoke earlier, that it's the Treaty of the Function of the European Union, not the Treaty on European Union. And they set out the areas of exclusive competence, shared competence, competence to support, coordinate or supplement actions of a member state, and competence to provide arrangements within which member states must coordinate their policy. Now, this is all very techy and not something we need to get into here, but suffice to say, the type of competence the Commission has varies by subject matter. What's important for the purposes of the ECI is that the proposal falls into one of these areas. And, I mean, there are differences, I think. If the Commission, if there's an area of exclusive competence, this means that the Commission is free to legislate, and the member state must fall in line. Once a regulation or a decision has been passed, member states, that becomes directly applicable in the member states and directly effective, and there is no requirements for the Commission to coordinate or to share competence with the member states. So that's, in a sense, the strongest form of competence. When you have shared competence, that's an area where both the member states and the Commission have some power of legislation. And what that means in practical terms is that the Commission doesn't have a fully free palette. They don't have a carte blanche. They don't have a full room of maneuver, if you will, in order to pass legislation, because there's going to be other legislation at the member state level which may prevent them from carrying out what needs to be carried out. And that's important when looking at the subject matter and the requests that an organizer has, because they may be asking something which the Commission just can't do because there's already legislation in that area. But anyway, you have there the different policy areas, and I have up on the slide just a screenshot of a couple there, and it's just alphabetical, so agriculture, budget, competition. But if you look there, you can see the key areas. And once you've found a policy area, so I think the first question to say is, does this ECI proposal fall into one of these areas? Can it be shoehorned into one of these proposals? If it doesn't, we need to think again, and the organizers have to go back to the drawing board. If, however, we have a proposal which fits in a policy area, then we have to say, can we find a legal basis in the treaties for the Commission to act? And that requires, and you can see also on the slide, there's a list of the treaty articles which apply in each of these areas. So if we have agriculture and fisheries, that's Articles 38 to 44 of the TFEU, and so on. And then it's necessary to go and have a look at those articles and see what do those articles enable the Commission to do. And because they're listed here, you will find often there's a reference to an ordinary legislative procedure, or it will say the Commission shall propose a legal act to XYZ, and there'll be language there which shows this is an act, this is a legal basis in which the Commission can take an action. And that's really important, because if we don't have that legal basis, if the organizers, let's say, refer to an article which does not allow for the Commission to act, or which gives the Council the primary legislative role, then that cannot be used in order to bring this proposal forward. And this is where, to be honest, as legal experts, we have to do a little bit of legwork to make sure we understand that there is a basis, and this is where really, as Angeline said, sort of the best training is on the job. Now, once we've got there, and sorry, I put in Article 13 of the TFEU here. Now, interestingly, and this relates to animal welfare, and there have been several proposals relating to animal welfare, several of which have been rejected, and one of which is the Stop Vivisection proposal, has been accepted. And interestingly, I mean, animal welfare is a good example of a tricky area, and that is because animal welfare is definitely, as you can see from Article 13 up on the slide, animal welfare is dealt with in the treaties. And Article 13 says, in formulating and implementing Union agricultural and other policies, the Union and Member States shall, since animals are sentient beings, pay full regard to the welfare requirements of animals. Okay? So we have a clear directive, both on the Union and the Member States, to take animal welfare into account when they are implementing Union policies. And so in the early days of the ECI, there were several enthusiastic organizers who thought, well, let's outlaw cruelty to animals, let's stop bullfighting. All very laudable aims, all very good goals. The problem is in their proposal, they asked the Commission, without any reference to the other competences that the Commission has and the Union had, to pass a law which just abolished these abuses and these certain practices. And the Commission had to reject these proposals because they didn't link that the requirement to take animal welfare into account into a policy area where the Commission had competence. So the point is here that animal welfare is not a standalone area of competence of the Commission. It has to be linked to policies that the Commission is otherwise implementing and has power to implement. So that's why animal welfare can be taken into account, but it cannot be used as a standalone basis. And so that's the sort of nuance where often we have to do quite a bit of thinking to make sure that what is being proposed actually fits within the framework of the treaties. And then, so the final element of this is the legal act. And, you know, we need to ask the Commission to pass an act which they have power to pass. You know, if we ask the Commission to make, or if organisers ask the Commission to make, you know, great statements, to, you know, have a holiday, have a demonstration, I don't know what it is. There's lots of things the Commission can't do. There's a limited number of things they can do. And what they can do is they can pass legal acts. And there are 5 legal acts, and these legal acts of the EU, and these legal acts are set out in Article 288 of the TFEU. And sort of in order of importance, you have regulations, you have directives, you have decisions, you have recommendations, and you have opinions. And, I mean, some of these will be very familiar to us. So the regulation is sort of the highest order of secondary legislation in the EU. And a regulation is directly applicable in the member states. Once it is passed, it immediately becomes law in the member states. Then you have a directive, which is sort of the second tier. And a directive is an instrument which, once it is passed, it does not become directly applicable in the member states. Member states have to pass implementing legislation in their own domestic legal system to transpose that international law. There's quite complicated case law about directives, which you won't go into, but that's the basic idea. And then you have a decision, and a decision is directed to specific addressees. So in an example, a very good example from our own work here is when 2 parties notify a merger to the Commission, and the Commission looks at it and they say, yes, that's fine, you can go ahead with your merger. They issue a decision to the parties. So that is a legally binding act. It doesn't have applicability really to third parties, or at least only third parties with specific interest. It's very focused, and it doesn't have general applicability. And then you also have, and all of those, by the way, are legally binding. So they have force in EU law, and because they have force in EU law, they have force in national law. And then you have recommendations and opinions, which are non-binding. Now, obviously an organizer is going to want to have the most, as legally binding as possible an action. The reality is getting a regulation across the line is going to be a pretty tall order. I mean, that's a tough thing to do. Probably they don't just want an opinion, because opinion is maybe just hot air. But somewhere in there, organizers have to decide what is the legal act that we want the Commission to do. And that's obviously often something to think about, and think about, okay, you know, how can we package this? What do we want to ask for? Now, in reality, you know, the Commission may not, the Commission has discretion, basically, whether they, once a proposal is submitted to them and they receive, a million signatures, they have discretion as to what they do with it. But it's often a good idea to think about this. What is the legal act that we want in the first place? So that's an overview. I'm now going to hand over to Angeline, who's going to look at a bit more sort of practical tips for organisers when you're reviewing these proposals.
Thanks, Daniel. So indeed, with that legal background, which we hope you found a useful refresher or a useful introduction, depending on your level of pre-existing familiarity, we wanted to spend a moment or two on the practicalities of your role as legal expert, and the way in which you will be working following the receipt of inquiries from citizens. Ultimately, the way this is going to work is we just had a problem with the slides there. We're just getting them back on track. when an inquiry comes in, Elisa or someone at ECAS will be your point of contact and will send you a citizen's proposal, which you then will have a number of days to have a look at and to provide some feedback on. And what we envisage is that you will have a template which will look something like what we've put on the slide, whereby in doing your review, you will track what it is the citizen proposes and you will provide some feedback, which will be focused on giving them some legal advice in light of all of the background that Daniel has talked you through, and also potentially some practical advice based on your experience. The key items here, 1 to 6, you will, of course, now recognise having had the introduction, and these headings are also set out in the annex to the ECI regulation. So this is correlated to what the requirements are in order to have a proposal registered. Before we go through each of those items, there may be some golden rules, as we've called them here, that you should keep in mind for every proposal. I mean, first of all, as Daniel said, the ECI website is really your best friend. It is a really great resource, the FAQs in particular, the archive of previous ECIs, it's all there, and that will really be a very important port of call for you in carrying out your work on any citizen proposal that comes in. Secondly, familiarising yourself with the previous ECIs. Why is it that they were rejected? As Daniel has set out with a couple of examples, we can often read something into how the regulation is being interpreted and the likelihood of success based on the previous reasoning. It's also important, depending on the subject matter of a proposed ECI, for you to be aware of the extent to which that subject matter has been considered in the past, and whether there are potentially parallel ECIs at the same time. Has there been one that has been registered and maybe it's in the process of being further considered? Has it been rejected? What were the reasons? So all of that, I think, as a preliminary matter, as a point of initial research, before you start looking at legal bases and legal acts and so on, I think the first thing that you will need to do when you get a proposal is to look at it in the round and to consider whether there have been previous ECIs that should be taken into account. And the third golden rule, this goes a bit to your written advice and your written input. And of course, we are mindful here that the role of you, the role of ECAS, this whole initiative is all about supporting ECIs, and we want as much as possible to be a force for good in terms of those statistics and tip the balance as much as we can towards having ECIs accepted. And so what you should have as your mindset then is, when you are providing feedback, be careful that we do not inadvertently prejudice the success of a proposal. So, for example, if you think it's highly questionable that a particular proposal has a valid legal basis, we should really think about, is that something that is so clear-cut that we want to state it in that way, such that the proposal would maybe go no further, or even that the European Commission would ultimately see the feedback provided via the platform and would see that a legal expert has said, we don't see a legal basis for this? Or is there potentially an arguable case? And in any event, it will be appropriate in phrasing your feedback to be as constructive as possible and to say things like, consider an alternative legal basis, without having to say we think your existing legal basis is wrong. Having said all of that, where it is clear-cut, we should of course be clear. I just want to flag to you that the feedback you provide will be visible to the European Commission, and we want to make sure that what we document as legal experts as we go along will always be construed in the most constructive way possible and will not lay a trail that could in any way prejudice the success. I mean, at the end of the day, I would expect that, and we've seen from the examples that the quality of ECIs that come in can vary. But at the end of the day, it's the quality of the idea that is most important. And so we want to make sure that we are very focused and that we give every ECI a fighting chance to get registered and to continue. Okay, so maybe moving on from that, so the things that practically you will need to check. So first off, the title of the initiative, a minor detail in the scheme of things, but something not to overlook, that the title, it needs to have a title. There is a requirement that it should not be more than 100 characters, so that's something that we should check. We don't want to have any latent reason for an ECI proposal to be rejected. There's no other particular legal requirement there, so long as it's 100 characters, there isn't really anything more for you to do as legal experts. But, you know, if you have other constructive guidance, do feel free to pass that on. You know, is the title accurate? Does it cover the subject matter in an adequate way? If you have an alternative, an improvement, do feel free to pass that on. That's the title, and that's the easy one. Next is subject matter. So the subject matter must specify what the legal act of the Union is, and Daniel has given you the background on that. Again, there's a formality here. The subject matter should be expressed in no more than 200 characters, and we should check that. One of the, and then we have covered here as well, and you will need to check that what legal act is proposed within the subject matter, whether it's a regulation, a directive, or a decision. And I think that you should consider whether the proposed legal act is appropriate in the circumstances, and any kind of constructive feedback, whether the subject matter as described and the specific legal act that is envisaged are appropriate in the circumstances.
Can I mention one thing?
Sure.
Just one thing to add to what Angeline was saying, and sort of to add to what I was saying previously, is when we're talking about the legal act, it's worth bearing in mind that we can also ask the Commission to change existing EU legislation. So let's say, and in a way that's in some ways an easier way to get in, because let's say there's a directive out there or a regulation out there which you don't like, which we think, let's say, you know, there's banned glyphosate. We don't like the fact that glyphosate can be used and that there's EU regulations that cover glyphosate. It is perfectly legitimate as a subject matter of an ECI to ask the Commission to either, you know, to repeal it, or to ask for the Commission to change some aspect of it, and often that's quite a nifty way, if you will, of getting in the door. But that's just something to bear in mind. Yeah,
absolutely, and indeed I was going to mention that on the legal basis slide, but it's good that we bring it up here, that it is important to check if there is existing legislation covering the subject matter in question. First of all, to check whether or not this ECI is really needed. Secondly, to understand if there is something expressly contrary to it already in secondary law. Or thirdly, as Daniel has explained, this may be the easiest way to establish a legal base, because you can point to legislation that can be amended. So, then the next item that the proposal must address relates to the description of the objectives. Again, the formality, maximum number of characters is 500. That's something we should be routinely checking. The main objectives, I mean, this is quite an important part, together with the subject matter, the key kind of drafting here, and which go not only to the legalities of all of this, but also to how we sell it. I mean, in many respects, the main objectives are part of the key pitch for why we think the ECI is laudable. So the practical advice here, when you review the main objectives and verify that they are no more than 500 characters, I think we would very much encourage you to take an extra moment to review it and make sure that there is a clear and brief articulation of what it is that the ECI is designed to achieve. I think it's fair to say, without naming any examples, that Daniel and I, in our previous work with ECAS, we have sometimes come across proposed ECIs where actually, frankly, we've struggled to understand what it is that's supposed to be achieved. So it's key to have that crystal clear articulation of what is the issue and how is it that it's proposed to be resolved, and all of that should be linked to identifying the legal act and the legal basis. You want to add something there?
Yes, Angeline, thank you. I mean, that's what Angeline said is entirely right. I mean, I have it in front of me, some advice that we gave to a previous ECI, and I won't mention the name, but one of the comments that we had was that the proposed initiative was just so ambitious in its scope, and it was to do with migration and resettlement and the treatment of refugees and migrants, and I think there were 3 different proposals. Each of the proposals was very broad. And I mean, they were asking the Commission to do so many things that you struggle to see how the Commission would be able to take this on board. Secondly, it wasn't clear what they wanted. So I mean, one of the proposals was, and I quote, help victims seek justice to fight exploitation, crime, and abuse. Once again, that's a brilliant thing, and we should absolutely be doing that. But what the proposal failed to do is it failed to state exactly what the legal acts that they wanted the Commission to do. They didn't want the Commission to go away and cry and say, that's very sad, we're sorry about that. No, that doesn't do anything. We have to say what the legal act is and be very clear about this. And I think this is where we can really help, is that as legal experts, we've not been in the middle of this for 3 or 4 months. These guys have been working night and day on this, and they've lost the perspective. I think we have the outside perspective and can say, hang on, wait a minute, what is it we want to achieve? How do we make this realistic? How do we specify this in a very concrete way?
Okay, so then the other specific act that we have to check is the legal basis. I'm not going to rehearse again everything that we've said about the importance of this, but maybe just a couple of practicalities. First of all, make sure that the proposal is citing a legal basis, and if it's not citing a legal basis, consider whether we can propose a legal basis from our own research. So I think that has to be part of our role. There may be circumstances where we feel there is no legal basis and we want to give written feedback that we have not been able to, that a legal basis is not specified. But I think in practice we should also do the other step of considering legal bases. Then for any legal basis that is cited or that we then investigate, it's very important to track through the language in the treaty and to spot Is this something via the ordinary legislative procedure or the special legislative procedure? And making sure, in particular if it's a special legislative procedure, that the article explicitly mentioned that the Commission is responsible for making a proposal. So what you'll see in some treaty articles is that it will say the Council acting on a proposal from the Commission, etc., etc. So that would be sufficient, that wording, because it makes clear that the Commission is responsible. In other articles, you will see that there is a reference to the ordinary legislative procedure. So it's just a matter of doing the diligence and going through that and tracking it in the written response. Go ahead, Daniel.
Is it, sorry to keep interrupting, I just have an example you may want to take a note of, just so you can see this language in practice, and this is just pulled out of the air, but Article 78 of the TFEU is a good example of where this kind of wording comes up. And Article 78 is about the EU developing a common policy on asylum, and so subsection or clause 1 states the Union shall develop a common policy on asylum, subsidiary protection and temporary protection with a view to offering appropriate asylum status to any third country national, and it goes on. Then section 2, provision 2, article 2 says, within this, it says, for the purposes of paragraph 1, the European Parliament and the Council, acting in accordance with the ordinary legislative procedure, shall adopt measures for a common European asylum system comprising, and then there's a list of A, B, C, D, etc. So that's exactly the language which signals to you that article can be a valid treaty basis for the Commission to propose a legal act within the framework of its powers for the purposes of implementing the treaty. So that's just one to have a look at as an example.
Okay, and again, for reference, we can't emphasize enough how important it is that you familiarize yourself with the ECI website, with the FAQs. We've put up here the FAQs relating to the EU competences, and you see here that you can search that not only according to subject matter, which we had on the earlier slide, but you see here it's also possible to search according to exclusive competence, according to shared competence, and there are links in there. So this is really the key resource and the key starting point for you to begin your checking on the legal basis. Okay, and just then the final point to mention is that there are some documentation requirements which the organisers should attend to, and as part of the diligence of checking all of this, it's good if you can also go through each of that the correct personal details are listed of the committee members, and that there's the proper documentation and so on, that's all set out, so as to avoid that there would be any technicality on which registration could be refused. And that takes us to the end of what we were proposing to proactively present to you. So a kind of combination of the legal background and some practical words on what this means in practice. We're happy to open the line to questions. I'm conscious that you're all in different locations, so maybe if you have a question, if you feel free to unmute your line and introduce yourself, and we're happy to address any points you have. No, sounds like no questions. But we will generously take that as a good sign that we have covered any possible question you could have had. nevertheless, if following this presentation, if you do have questions, you should feel free to reach out to Elisa and also to us so that we can address it. We can address it after the fact.
Sorry, Angeline. Hi, I have a question.
Hi.
Hello?
Yes, go ahead.
As regards the 7 member states that they need to collect signatures from, this is not our responsibility to check. I mean, this is something that will be done later on, I imagine.
Yes, that's correct.
Okay. Thanks.
Yeah, maybe I can clarify a bit. So basically, we're creating this online collaborative platform, which is the ECI forum, and there are like multiple functions in the ECI forum. But the only one in which you are involved is called Seek Advice. And basically, under the Seek Advice part, ECAS will be giving advice to citizens on 3 different issues: legal advice, campaigning advice, and fundraising advice. And of course, you as experts will be only involved in the Seek Advice part under the legal advice. So it's really only one of the functions of the online collaborative platforms. And there is also a disclaimer, of course, in the online collaborative platform saying that this is an advice to potential organizers. It does not mean that the Commission will automatically register their ECI once it is submitted. And I just wanted to also say a thing which I would like to stress is that in the past, the Commission would either register an ECI proposal or reject it as such. Now, the Commission in the past couple of years has been doing also partial registration. That means that if there are some points of the ECI proposal which is not okay with the Commission will still do a partial registration of the ECI. And this is really a fundamental change because thanks to this improvement, many ECIs have had the chance to be registered, although they had to drop, for example, 1 or 2 points from their proposal. So this gives you also a margin of flexibility when you're giving the advice. You can also go back to the organizers and basically say, we think that there's less chance that this point will be possible, but since they allow for partial registration, most probably your ECI will anyway be registered, like dropping that point. Then another thing I wanted just to tell everyone is that the launch of the ECI forum is now delayed. So we haven't launched the forum yet. It will be launched only in May. So this also gives you a bit of time to check out a bit better the regulation, etc. And of course, more on a political level, the Vice President Timmermans has also proposed to the Parliament and the Council basically a revision of the regulation of the ECI. This will not change anything here for now because it will take at least until the end of the year for a new regulation to actually be in place. So at the moment, we're just working on the current ECI regulation. So no problems there. Of course, you will be informed if next year during the pilot project, they change the regulation, then we shall talk about it then. But for the moment, it's just the normal regulation. Are there any questions also on the terms of references or anything? All right.
Okay, but if there are then no questions, we would thank you all for participating and for your attention, and we wish you all a good afternoon.
Thanks a lot for joining us.
Thank you very much. Goodbye to all.